Okay, welcome everyone on this Friday afternoon immediately after lunch. Probably people will start coming in, but we only have 75 minutes, so let's get going. I'm Ronald Leenes from the Tilburg Institute for Law, Technology and Society, and I'll be chairing this session this afternoon. We've had a number of privacy by design, privacy by default sessions already at this conference, but apparently the topic is hot and people still attend these panels. And I haven't been able to attend all of them, but at least the ones that I attended gave me some lessons. And one is that implementing privacy by design, especially through technical means, is maybe a hard thing to do. And I'll show you the lovely prose of Article 25 that we're dealing with, and that shows you already part of the reasons why that is maybe complicated. Now, I have worked in access control and policy languages and formalizing legal rules into code. So I am one of the people that is a bit skeptical about hardcore technical measures for implementing privacy by design. But I've also become a little bit of an optimist at the same panel, where Marit Hansen, the Schleswig-Holstein Data Protection Commissioner, argued that enforcement, or at least asking questions to data controllers about what did you do in terms of privacy by design, may eventually push to the adoption of privacy by design. And I hope that this panel, and I'm pretty sure that this panel will foster my optimism even more, because we will shift the focus entirely in this panel. So instead of talking about the issues surrounding the implementation of privacy by design and by default, and whether or not that will lead to adoption, we will not take privacy by design and default as an obstacle, but rather as an opportunity in this panel. And the reasoning here is partially that we already see a sort of a Brussels effect. So the content of the GDPR affecting and impacting policy around the globe. And because privacy by design is a requirement in the GDPR, we're basically telling European data controllers, you have to work in this space. And when the world finally wakes up and considers privacy as an important value, then European companies might have a competitive advantage over others that have to start up this whole thing later on. And the other thing, of course, is that we also have, I mean, the audience here generally believes that privacy is an important value and that data protection is important. So we have also enterprises and people that take this whole thing seriously and see privacy and data protection as a unique selling point for their product. And so hence the question that we will be addressing here is how can EU privacy rules, both the GDPR and the upcoming mystery horse ePrivacy regulation, foster innovation based on privacy by design and default principles. Now, I'm happy with the panel that we have because we have people with totally diverse backgrounds. Look up their backgrounds online. You know Google, and that's your friend in this case. But we have Guillaume Champeau, who represents a company that offers a privacy-friendly search engine, which you need to check out, and they also sponsor this session. So he will obviously talk a little bit about his work in developing privacy-friendly approaches. We have Nina Marnau next to me, who works at the intersection of law and computer science, so she understands both what you see on the screen and things about implementation. We have Isabelle Chatelier in the middle from DG Just, who can tell us more about the reasoning behind Article 25 maybe, and maybe also something about enforcement, but I'll leave it as a surprise what she's actually going to do. And then on the far end we have Matilda Sisatto, who will provide us with a view from the European Parliament. And I'm also very glad that we have Pat Walsh as the moderator for this panel, and I gladly transfer the microphone to him.
Thanks, Ronald. Well, thank you for being here. It is Friday, 2:15 and after lunch, and you're brilliant, I think. We're going to let these guys each have their own view. I want to give as much time to you to ask questions and have the ability to ask questions of these guys because you don't often get the chance. But as we go through the privacy by design and by default, just think about a few things. So what do we mean? Defaults can be protective or they can be harmful, for example. We've heard that a few times. So think about some of these things as we go through how people do data protection by design. Think about user agency and settings. Minimal user agency can possibly lead to greater harm, for example. And then think about, if you think about, you've all got a smartphone in your pockets, haven't you? At least one, probably. I work in the mobile industry, so thank you. Think about, you've got a handset manufacturer and you've got an operating system vendor as well. So think about who has responsibilities in privacy by design. If we're talking about it should be a holistic approach taken, what do we do? And then think also about chip manufacturers. Chips are increasingly intelligent and will play a greater role as we move into an IT environment. Now, for a decade, I've tried to find information on what chip manufacturers do and some of the data they collect, and I'm still struggling to get that. So they're some of the things. We're going to hand over straight to Guillaume, I think, to provide an industry perspective on how Qwant has taken on this issue.
Sure. Thank you very much for the introduction. Just so, as Pat has told you, Qwant is a search engine, but our main focus is really on protecting privacy. And why do we do that? First, it was a question like, how is it possible that of pretty much all the most visited websites online and most used services, they're all American or Asian? Why is that? And we think that's because we failed on two grounds. First, as an industry, we've tried to just copy what the others were doing and trying to be better at them than, for instance, trying to collect as much data as possible in order to have more data than the big American companies. And obviously, it's really hard to compete on this ground because those companies will always be better than you at collecting data. So if your services rely on collecting data, the chances are that the American companies that have more data than you will have better services than you. And also, we failed collectively as a democratic society in Europe to protect our values because we've let in companies, especially American companies, who don't really care about our privacy laws. And we don't have to wait for the GDPR. They're already infringing our current European laws on privacy issues, and still we are letting them entering our market and setting whatever things they want, including on our mobile phones and taking all the data that we have. So really the thinking behind Qwant was try to reverse this situation by first creating a search engine that would have something new, that would be respecting people's privacy by not having any of your search history, by not having any cookie that might enable others to track whatever you do online, whatever you search online, whatever you're interested in. We won't change the results based on who you are because we think that it's very important that you have as much neutral view of what's on the web and that it doesn't depend on an idea that we make of your status of interest or your age or your sex or sexual orientations, your religion or whatever. So it's really about protecting your freedom when we want to protect privacy. And we think that if we convince people that protecting your privacy is good for you as a user, is good for you as a consumer, then it's good for us as a business because you will start to choose our service over American or Asian services because you know that on our service, your interest will be better protected. And in the end, and I think it's the philosophy behind Article 25, it's really about building a sustainable digital development. Like we've all heard about sustainable development regarding the environment, like watching the carbon emissions are something that we should avoid. And we believe that personal data should be viewed as carbon emissions as well, the fact that you collect personal data, and that it won't be sustainable to collect more and more data every year. Like think about just the fact that we are in 2017 and already we have companies that have 2 billion users that know every search queries that you do minute by minute, day by day. They know the videos that you watch online when you watch them. They know the news that you read online. They know the websites that you visit. They have they're beginning in the United States to have access to your bank accounts. They deduct things from the search queries you make. They know the applications that you use. They know everything about you. And still, it's just 2017. So what will it be in 2027, in 50 years from now? I mean, it can't be a sustainable digital development if we go on collecting as much data. We will just give up the right to privacy and say that the economy is everything that's really the thing that cares the most. And I think that as a European, it's not something that we want. Like, we have values and we should defend them. And really the logic behind Article 25 is to build this sustainable digital economy, which will be based on the best practices regarding protecting people's privacy. So still having efficient services, but with the minimum data as possible. So that's it.
Thank you, Guillaume.
Thank you.
What I've taken away from that is that Qwant seems to have, you see this as a competitive advantage, that
exactly.
Privacy by design, or data protection by design and default. But then you mentioned also the impact of search on things such as freedom of expression. So I'm assuming then in relation to Article 25, where it says, guard against the risks of rights and freedoms, that's been sort of central to the way that you've designed the service, including data minimization.
And it is one of the, I won't say problem, but one of the things that you have to keep in mind when you read Article 25 is that it asks companies to make like a risk assessment of regarding the fundamental rights of your users. But we, as Qwant, believe that search queries are very sensitive data, because let's say you're searching for, you're planning to do a pilgrimage in the Mecca, or in a city in France which is called Lourdes. It doesn't say the same about your religion. Like, in one case you're probably a Muslim, in the other case you're probably a Catholic. You're just very unconsciously telling us many things about yourself when you search online. Like, when you're looking for an apartment in the center of Brussels in a very demanded part of the city, it says something about your level of revenue. When you're searching for outside Brussels, a very small house far away, probably says something else. When you're looking for some website, it says something about your sex life. And people most of the time think that they are just behind a computer asking a search engine the best answer to a search query they have, and that it has no consequences, when in fact it has consequences, and especially when the search history is used to tailor the results to show or hide information based on who you are, and that also it's more and more used in personal assistance or AI-based assistants that just will, for instance, you want to go, you go to a city somewhere, you're asking for a bar, and it will advise you a gay bar, because based on your search history, we have decided that you're probably gay, and you don't have to precise that if you want a bar in a city, that it's a gay bar that you want. That's something that we consider very sensitive. And the search engine is not just about collecting information. It's really about giving you the information that you want when you ask for it. So,
so protecting rights. So what I've seen, though, I mean, because like a number of us, we were engaged on GDPR in 2011. That's how long some of us have been on this. Is that I've seen it drive innovation, particularly in the area of search. So you've got Qwant and a number of other privacy respective and protective search engines. That's one area. Now, I'm really happy that Leenes is on the panel with us. There are some fantastic researchers here at this conference. It's just brilliant. And you're going to talk about how Article 25 can and is fostering innovation in this space, in different technologies.
Yes, so thank you for the introduction, Pat. I'm a researcher. My main focus of work is privacy-enhancing technologies, and I really enjoy Article 25 and what I've seen for the last about 2 years since the text of the GDPR was final, was companies getting to my research institute, getting to me saying, we've read your papers, we've seen that there are innovative technologies that we would like to try out as data controllers, and they really want to work with us. And I had the chance to deploy some innovative technologies with companies from different backgrounds, with governments, with administration, with private companies from the mobility sector, the automotive sector, the health sector, and yeah, I enjoyed this work, and I've seen so much interest and growing interest due to the GDPR and these technologies. That makes me really happy. But of course, on the other side, there's a caveat, because these companies don't do this for the protection of the rights and freedom of the individuals, but because they want to be compliant and they want to have a cutting competitive edge on their competitors. And so what they ask us in the end is, where do these technologies help us? Are we compliant? Can you tell us whether we are compliant? And this is the big problem, because we don't currently have this much detail on how to interpret Article 25. How do we define the purpose? How limited does the purpose have to be to assess whether data minimization is sufficient? And in addition, we wanted to talk about these problems with the DPAs. So we try to get the DPAs on board and talk with them about our new developments in technologies. And they currently lack the resources. They lack the resources to give us fundamental advice, because they currently have to apply the GDPR in so many areas that they cannot focus purely on Article 25 and new technologies. So this is kind of a little drawback for us, because we cannot say, hey, apply these technologies and consider them in your data protection impact assessment and minimize the risk for the individuals and you'll be compliant, because we currently don't know what they need to do to be perfectly compliant. Yeah, thank you.
No, thanks.
Can I ask a question for the audience? What kind of technologies are you working on, and what is the demand? Is that access control? Is that helping out data minimization, anonymization? This is all new.
So it's mostly anonymization techniques. We are working on differential privacy, on new data aggregation techniques, also new cryptographic principles like secure multi-party computation. Maybe you've heard about it. So homomorphic encryption and functional encryption. These were mainly the technologies that we deployed.
So the first thing I took away from Nina's intervention is that she started with the word, I enjoy Article 25. Remember, this doesn't have to be a burden. So, and I guess the audience can ask some questions. I'd like to know more about the way you're deploying differential privacy, for example, maybe a bit later, because Apple, that's what Apple are adopting. They're doing on-device encryption. Yeah. They're then using synonymous or anonymous data, also in a crowdsourced environment. So it would be interesting to learn more about how that can be done, and how, for example, you don't have to have the power of Apple to be able to do those things. Are those available to smaller startups and others? So it'd be great to learn a bit more about that.
Yeah, so absolutely true. If you want to ask questions regarding that and regarding where it can be deployed and where it can be helpful, please ask those questions.
So we're going to go to Matilda, and Matilda, I think you're going to talk a little bit about how where Europe is creating this environment where data protection and privacy are beginning to be taken seriously at a more global level, and you're going to talk more about that, I think, aren't you? Yeah. Maybe.
So, well, I wanted to talk a little bit about the logic of the legislator also, like. When we started working on both the GDPR and the whole data protection reform, including the police directive, we tried to have a sort of a logic where we would have the similar kind of rules for the analog world as we had for the e-world, and to basically respect the fundamental right that is for all of us, for our personal data, as well as now with the ePrivacy regulation to our privacy and private life. We had this idea, which originally sort of came from the Commission as well, that we want to build a strong, firm foundation, so then it would be easier from there on to have these products and systems that basically would be easier for the businesses to enroll out, for the consumers and the citizens to trust, and also for the oversight mechanisms, that there would be some sort of an ease for them to see what they are enforcing. And there we, even in the Parliament side for the GDPR, we had much more explicit provisions for data protection by design and default for the GDPR. We have similar sort of logic now that we have instilled in the ePrivacy regulation. And I think what we are aiming at, especially with the ePrivacy, is that we want to have a world where people can fully opt into all the new technologies and new innovations without having to be constantly armed up to their teeth with all sorts of protective measures. There was an interesting statistics that we have seen from the citizens, whereby, for example, when they were asked if they would like specific rules for the electronic communication sector on confidentiality of their communications, 83% of the citizens who responded, they said yes. Then again, 63% of the companies said no. They didn't feel they needed any specific legislation versus the 83% who said yes, we want it. And it's kind of understandable that you have this divide when you look at the players who are on the market at the moment. Because mostly, as was said before, the innovation comes from the US. And I would say that it's sort of understandable that we are in the situation where we are today from the legislator's point of view. Because normally this is the point when you have to run when people say like, oh, the ancient Romans. But the idea that we have in Europe is that from the ancient Roman times is that when you talk about your data is extension of your persona. And nowadays we have the Fundamental Rights Charter where it's very nicely codified, and because it's a fundamental right, because it's considered as such, it is actually in the hierarchy of laws, it has higher protection than all the other laws that we have. So it's the same level as constitution, so to say. And in the US, on the other hand, it is a completely different thing. In the US, the privacy protections they originate from property law. So basically, this is me, I live here, I can shoot anyone who comes around this area. They can't snoop into my things or my privacy, but it's not really seen as an extension of your persona. It's something that you own versus something that you are. And there's also another curiosity versus our legislation in the US, which basically is the fact that the legislative system is different. You can do whatever you want as long as someone else cannot prove that you're doing harm. And in the EU, in the European countries, we kind of have a different idea. We basically like to give you boxes. So I give you this box, and you can play in the box, and you can do whatever you want, but you have to stay in the box. And then the legislator kind of sometimes moves the limits of the box. In the US, you're free to do whatever until somebody realizes that, what you're doing is not good enough, so they're kind of trying to squeeze you in the box. So I think it's not about evil business versus evil legislator. I think it's sort of, because of the nature of internet and the nature of how these things developed, it's just kind of really difficult to put these two things together. And therefore, we are kind of in this funny situation whereby everybody's saying, oh yeah, US innovation grows and it's exponentially there, and you can innovate and you can do anything, and all the data that you can get, you can come up with new revenue streams, and it's sky's your limit. And then, yeah, in the EU, no, it's not very workable. Like, you have too many regulations, too many rules. You can't do this, you can't do that. But then obviously, we are constrained with our legislation and the sanctity of the protection of your fundamental rights. However, I think it's actually quite interesting these days to see where we're headed at internationally. We are seeing great shifts, as have been said and mentioned in this panel, but also the panels before in the few days we have had here. Already Mark Rottenberg was saying, I think it was Wednesday, that GDPR has made sort of a lot of influence already in the US, in their model, just because they have to be compliant if they want to be operating in the EU. But what he also pointed out, which is extremely interesting, is that because of their model and the way that their innovation has been headed at, they now are riddled with lots of problems when it comes to financial fraud, identity theft, and massive data leaks, both in a sense that their systems are leaking data and then actual mistakes whereby you release lots of data out by mistake. And therefore, I think what he was also saying is that this GDPR compliant innovation, that is kind of shifting back towards the EU. And some operators in America are kind of looking at us also going, well, these kind of certain types of phenomena is less prevalent here. Maybe it's also because of the systems that we have legislatively tried to impose or implement, or what we are actually now planning to do. And also, we had a committee meeting, committee trip to Japan because of the planned data protection agreement between EU and Japan. And it was very interesting to see there how the Japanese authorities and their data protection authorities were basically saying that they are now shifting their models more towards the EU, and they have actually stopped negotiating on these data transfer rules with the Americans completely. And now they're kind of looking at us and they are pushing this sort of a model also in Asia. When you look at South America, they are adopting principles straight out of GDPR, and they're trying to kind of assimilate the EU model more than the US model. So I think it's also interesting that other countries are doing this, and therefore I really hope that this is some sort of a stepping stone also for the European innovation, because now something that you used to see as a really constraining box actually becomes golden in a way, because if you can operate in that box, you're good to go pretty much anywhere in the world.
So among other policymakers then that you come into contact with around the world, because we keep hearing that the GDPR stifles innovation, that it's bad for innovation, right? I've yet to meet an example of that, but are you finding that policymakers in other countries believe that a GDPR type approach can help drive innovation, create innovation, various aspects?
I think so. I mean, of course, we have limited possibilities talking to different companies. We're not directly able to do that like that, but when we are traveling. But I mean, for example, the companies that we met in Japan, they were very much driving that they all were GDPR compliant. They were GDPR compliant already. They were saying that these are the sort of systems that they are implementing globally. They are using these standards as the global standards. They had BCRs, and they were saying that, well, there was only one company that had the BCRs, but they basically said that they kept this now as an international level for their data protection and privacy. So for me, it's very positive, that development.
So, well, that's interesting, because there's an argument, isn't there, that the defaults at the moment where your data is harvested, your data is broadcast live from your device every single second, and the ecosystems that mine that data are dependent upon that broadcast by default. Here we're talking about something that turns that on its head. So the innovation in those sectors often have been driven by that broadcast and that harvesting and that mining of that data, because the default is in the business interest and not necessarily in your interest. So I think as we go through this panel, I'll be interested in understanding between those who are working desperately in this field, some of those answers if they've got them, but also then Isabelle, what's the Commission's view on how privacy by default can be done in practice? Is there a role for the Commission to create guidance in this space? And I guess something else is that we keep hearing, and some of us observe, is that the data protection authorities themselves are already stretched for resource. So will they have the resource to, and the appropriate skills, for example, to examine compliance in this space?
Yes. Thank you. First, I wanted to come back on this notion of this principle of data protection by design and data protection by default. These concepts have emerged already under the Directive 95/46 because it follows a certain logic. I mean, it makes good sense that for a practical implementation of the data protection rules, you need to start somewhere, and you need to find a way to embed these rules into the design of the products or the services that you are providing. And so, in fact, these principles help support this practical implementation of the principles into the design of the processing, and it is a translation in technical and organizational means of the data protection rules. So the legislator decided to actually introduce those principles into the text of the regulation, into the GDPR, and not only that, but to introduce it as an obligation for controllers to implement those principles, because it makes just good sense that the products and processings are reflecting the rules as they are being developed. So as it is now an obligation, of course, it has also some impact in terms of enforcement, because now it has become subject to enforcement by data protection authorities, and they can, of course, impose fines on controllers if they fail to respect those obligations that are now in the GDPR. And since these are strong enforcement mechanisms and quite high sanctions, there is no more economic advantage for companies for not implementing and not complying with those principles. Of course, we are aware that it will involve some costs for industry to make their processing operations in compliance, but in the midterm, those efforts, we think, will be rewarded. I totally agree with the previous panelist that this is, for us, beyond the issue of compliance, this is an essential element for innovation, that it is definitely putting companies at a competitive advantage, and that they will be able to distinguish themselves on the market and also with respect to users by providing those privacy features that the public is also hoping for. You have asked me the question of the guidance. Well, the Commission has helped prepare with the co-legislator this regulation. As such, the Commission doesn't have a role to provide guidance on the application of the GDPR. This is something that is left, it is specially entrusted to the data protection authorities. The European Data Protection Board has the task of issuing guidelines to facilitate consistent application of the rules of the GDPR in the EU. So this is a possible field for guidance in the future. As it was mentioned before, possibly for now this was not on their radar because they are looking at the application of a lot of other important obligations, but I wouldn't say that this is completely precluded for the future. And as to your question on the data protection authorities, indeed, they need to have the necessary skills and expertise within the department in order to be able to understand that. It requires a lot of IT policy experts in particular. In the GDPR, we do ask member states to provide data protection authorities with those necessary human skills, technical expertise, and also the financial resources that are necessary for their performance of their task. So it is now, I would say, in the hands of the member states also to make sure that their national laws and the way they are structuring their data protection authorities allows them to also benefit from the necessary skill sets that they would need to function.
Okay. Thank you, Isabelle. Well, rather than me ask them questions, I want to open it up to you guys. Who has questions that you'd like to ask? Someone must have something.
May I say something?
Yeah, sure.
Just I wanted to go back, please, to what Matilda said about her trip to Japan, which I think was very interesting. We see a lot of companies that today say they are GDPR compliant for several reasons. First, because GDPR is a marketing keyword that is very efficient if you want to sell a product now that GDPR is trending. But also because most companies don't understand what GDPR is about, and they think that it's just about having consent from the user. And if they get the consent of the user to collect whatever information they want to collect, then they are GDPR compliant. When in fact, and to go back to the topic of this session, the key thing in the GDPR for me is Article 25. It's really about privacy by design. So it's not just about obtaining consent, but having as little data as possible. And you can only say that you are GDPR compliant if you design your services so that you have as little data as possible, and if you think about the impact of your services on people's human rights. So, for instance, if you collect the search queries, to go back to my specialty, which is search engines, if you collect the search queries of your dozens, hundreds of millions of users, or even 2 billion of users, you collect those queries every day, and you store them for months, for years, or for some users even more than a decade. Why? Why do you need to store this data? It's not something that you should do as a company. It makes no technical point at all to have this data. It doesn't even make sense to keep them for a day, but even imagine what it is for more than a decade. So you can't say that you are GDPR compliant if you do that. And as, again, the European Commission and the European institutions, should have this idea that they have to protect the European market. If a company pretends that they are doing GDPR compliant things, when in fact they don't, you have the duty to protect the European consumers, the European citizens, to help them understand that this service is not a service that respects the European law, and you have to make sure that the Article 25 is actually enforced, and make sure that the companies that don't respect them either don't have access to the market or are sanctioned with really important sanctions when they don't respect Article 25.
So, Stuart, I think you have a question.
I'm Stuart Dresner from Privacy Laws and Business. We're the world's longest running privacy publication. And I think this session is really good. What we'd like to write about are any companies which have actually taken on board privacy by default. We'd love to write some case studies. So anyone on the panel or indeed in the room who knows of any company or any organization who's actually done this thing and be prepared to talk about it, either by name or anonymously. How did you do it? How did it work? What have you seen any commercial benefits? So have more consumers taken an interest in your product? Now I know Qwant, you set up with that from the start, so that's not a typical case. What about a company that's already established for how many years, doesn't matter, but now taken on board this as a new thing? How's it been working? So anyone, that's what I'd like to know. And so either you can put your hands up now or see me later, and we'd like to write up some case studies.
Okay.
We have a client that's actually they're a startup at the moment, but they're creating a medical messaging app that would be compliant, that's much more lightweight than the large content management systems that American hospitals use to be HIPAA compliant. So I could maybe talk to you about that afterwards.
Yeah. Any more questions? Oh, Simon?
So, Simon Ania from TomTom. I would like to look a bit at Article 25, because to me it seems like it basically says you need to have quite a lot of measures, and they seem to be quite technology focused. Yeah, sorry. So if you look at Article 25, to me, a lot of the things you need to do seem to be of a fairly, let's say, technical IT, information technical level. So if I'm a controller and I go out there to buy a solution that will offer me something that I can use to do my HR management systems, I typically end up with software as a service and typically a data processor. So I would like the panel to reflect a bit on how to deal with situations like that in which you do select means and have to decide on purposes, in which you are going to engage with a processor, and how would that work in the process of applying data protection by design, which in my view, by the way, is different than privacy by design, but that's another topic. But how do I apply data protection by design and by default in cases where I engage with a supplier who will act as a data processor where I bear all responsibility for something which someone else will be delivering to me? And I would also add to that that there's not that many companies that offer these kinds of solutions.
Well, I'd argue that under Regulation 24, you're fully responsible for that. And when it comes to your data processors, then that's for you to choose a data processor that can provide those sufficient guarantees. But, well, pick a provider that can meet these obligations. But
how do I find out? This is a practical question.
I absolutely agree with you. It is a practical question, and I think market pressure alone and having it in the contractual guidelines and in the procurement guidelines might not be enough. But I think this is where the certification scheme of paragraph 3 might come into play, because we have to really come together as a community and quickly work on certification schemes that might help us, for example, with the procurement of privacy by design friendly processors.
I'm working with some clients at the moment, Simon, where, yes, we're going through with those vendors at the moment precisely what do we mean by, for example, what are the risks? What are those rights and freedoms? Because what I find with a number of entities at the moment who have addressed sort of risk from a traditional point of view, which is about, well, what happens if we have a data breach and we have a bad headline and we get fined? Whereas at the moment when you ask them, particularly in the communications sector, do you understand what is meant by rights and freedoms? They've never had to explicitly think about those, whilst they should have. The GDPR is making them think what that actually means, and the interrelationships in context that can drive risk, for example.
But answer the CIO, the CIO of this 500 MB company. How should we do that? Because you can't wait for certification schemes. He hardly understands GDPR. So what should that company do in order to avoid basically misusing the data of his employee?
Well, I think Article 25 is fairly easy to break down into to measurable elements, but also into deliverable elements. For example, first of all, different sets of data have different have different risks. The context of processing carry different risks. You have to do all of that in this too. And you also have to think about, well, actually, if it's not an enterprise kind of solution, but it's a consumer-facing solution, well, how do you deal with things like comprehension? How do you deal with things like ensuring user agency? When you're setting a default, how do you make sure that default is protecting my risks? Did you have a...
Well, yeah, I think this is a very interesting question, but I'd like to get back a bit to the previous question, and the question that was sort of underlying that in a sense. So we know that we have to do a lot of catching up, right? So privacy enhancing technologies have been around for ages. Basically, the directive already talked about that in a sense, and we know that there's not an awful lot out there. And so there are two discussions on the table. One is about how do we become compliant with Article 25, but the focus of this panel should really be how do we innovate, or what is the role of privacy by default or data protection by default and by design in innovation? Is it merely that we're trying to catch up with, let's say, bad examples and bring them up to reasonable standards, or do we see really data protection by default and design as really innovative products, and what do they look like? And that is basically the question that you asked. So what are good examples out there of entire product services or maybe just components? And I think so a question from my part would be to the policymakers, basically, do you have an idea of whether this is initially really a catching up exercise, or do we sort of try to get as fast as we can to an innovation stage. And then also maybe to Ninja and Guillaume, how do you see innovative products in this, bearing in mind these design principles?
No, and that's a really good point. I mean, 4 years ago, I started work on a technical standard for a global identity solution. 4 years ago, we started looking at this. 4 years ago, we started building this in, Simon. So, you know, instead of, for example, a mobile number being presented, we're using a synonymous customer reference. We are erasing data that authenticates whether that number is a valid number. Within 500th of a second, that data is destroyed. It's completely and securely erased. So there are ways to do this, to be honest. But I want to go back to you, Nina, because I made a note here about the differential privacy tool. You've been talking about using this with different clients. But I wondered if you could explain more about how, with those clients, have you had discussions on things like what a risk to fundamental right and freedom might be, and what the defaults might be appropriate in according to the different contexts, the different data categories, the different contexts of processing, etc.?
So yeah, I would have loved to give you an example of a company who has a previous business model and now applies data protection by default. I just can't, because the companies we have been working with were more focused on the by design aspect, as they don't mostly rely on consent but want to work on anonymized data. They want to have the personalization and the personally identifiable data out of the picture as much as they can have it. So they are not much relying on defaults. And with regard to the differential privacy question, yes, we absolutely focus on the risk. We know that anonymization of larger data sets is incredibly complex and really, really hard to do. And we can only make predictions about maybe the next 2 to 3 years whether computing power or publicly available data sets will come around and break our anonymization that we previously thought was secure for the rights and freedoms of the individuals. So yes, we have to be very clear about the risks, and we have to apply other measures on top to secure our anonymization. We have to segregate this data, we have to apply additional organizational measures, so it's a whole holistic bunch of security measures that we have to apply to make it work.
And have those clients, have they been pretty, because I made a note here that you were talking about compliance, but if it's just a tick box exercise, does that tick box exercise actually really reflect the risks to what are fundamental rights and freedoms, which are multiple? It's not just privacy, but it might be freedom of association, freedom of movement, for example, freedom of expression. A lot of these are actually interrelated, both. And when we think of Article 25, you know, it talks about the amount of data collected, the extent of their processing, the period of storage, for example, their accessibility. How have you dealt with that with some of the people that are seeking your help?
Well, we had a look at the existing frameworks. There are some EU projects, FP7 and Horizon 2020 projects, who try to come up with frameworks how to do a data protection impact assessment, what risks to take into account, but they are by no means perfect and complete yet. So this is kind of a trial and error for us, because we try to find the appropriate risks, and now when you put even more ethical considerations on top, I don't think we are there yet from a researcher perspective. I don't think we have a complete picture of what has to be included into a DPIA yet, and this is something we need to continue discussing.
Okay, I'm just wondering, Matilda, during all of the various and protracted discussions on GDPR, whether this particular aspect came up as a challenge for businesses who, of course, arranged many meetings in the Parliament, etc.
Yeah, of course. I mean, which part of the GDPR was not a issue of debate and lobbying. I think what we kind of decided that for us, the protection of the fundamental rights was the sort of the main thing, and I think it's partially the same sort of logic that you have with environmental or a chemical legislation or health legislation, in the sense that when you find that something is detrimental to the person, then you basically, the legislator has the obligation to legislate and to protect the rights of the person or the person, the physical person, from harm. And I think this was the guiding principle. And there came a point, I guess, where we really wanted to change the system from this tick box exercise system into a system whereby, like I said, you build a foundation. You need to understand what business are you in? What data do you have? What data do you collect? What do you do with it? You have to kind of make this impact assessment to understand what you do, what the impact of what you do is on the fundamental right. What impact do you have on the people that you are serving, so to say. It's the same sort of thing like you have environmental impact assessments. You need to know what kind of pollution levels you have. You need to understand what you produce, what is the output of what your actions. And I think this is really the whole point, is that you don't go through tick box exercises. You need to be able to demonstrate that you are compliant. You need to demonstrate that you're not creating harm.
I completely agree. First and foremost, Article 25 and also the data protection impact assessment is an exercise for companies to understand their own data processing, to understand what the purpose of their data processing is, what data they really need, what is really necessary for that purpose, and then find out the risks and the impact on the data subject.
And I just wanted to come back to something both for Matilda and Isabelle. So on the question of is innovation, or how is innovation compatible with legal obligations, i.e. in respect of data protection by design and default, remind me, because you both, the Parliament and the Commission both did studies on how people feel and other aspects, the impact of GDPR, and also on the ePrivacy proposals. Did those studies look at this dimension, i.e. the degree to which the proposals either fostered innovation or would harm innovation? Was that part of it? I can't remember.
Well, the Parliament studies were not on those aspects. They were mainly on the Commission proposal. Yeah. What the effects of the Commission proposal, not so much on these topics. I don't remember that the Parliament would have been explicitly looking at that.
Okay.
Yeah. For the Commission, I think it was also understanding more from the user perspective what were the lacks, the points of gap at the moment. What we looked into also was more to see how we could simplify some of the regimes in order to get rid of unnecessary notifications, unnecessary administrative burden, so to take away some of the costs of compliance in these notifications to data protection authorities. So, but we didn't look at this particular innovation factor.
So Isabelle, I want to be a bit naughty, if you'll let me. So and it does come back to data protection by design and default, because this is about protecting people and safeguarding them against risks, right? And these are risks not that we think normally, but the Commission, when Viviane Reding was in post, threatened infringement proceedings against the UK government for not properly implementing, it was the ePrivacy Directive at the time, and if I remember correctly, it was about Article 15.1, and it was about the use of form by a number of communication service providers in the UK that was using DPR technology to basically mine your data to target with ads without even telling people. They trialed and tested this and were beginning to do it without raising awareness, without asking people for consent. Now, the Commission at that point threatened infringement proceedings, so the UK government changed the law on this aspect because it related to interception of communication. So I'm just thinking, if you see something where there's potential for harm because a sector or a large player that has a significant market share hasn't properly done this, can you envisage something where the Commission will take action and that in itself drives innovation in this space? Or? Sorry.
Yeah. Well, the infringement proceedings are very specific. I mean, in the case that you refer, it also implies normally that there is a national law that is not compatible with the treaties. So here, I mean, we have as a basis the GDPR. So just the GDPR in itself would not be sufficient for us to open anything because it's a EU text. But if member states' national laws, for instance, were to prescribe certain conducts in certain sectors, because member states have the certain margin of maneuver in certain sectors, for example, in the field of health, they can go a little bit further than the provisions of the GDPR. And they go further than that in a way that is not completely compatible with the logic of the GDPR and of the treaties, then of course there is a possibility to take infringement proceedings. But I just wanted to mention just that maybe this is not the GDPR and related legislation that is that can help in that way, because, for example, we have other legislative tools in the EU. For example, we have a directive currently on radio equipment, and this directive allows the Commission to adopt a number of implementing acts and delegated acts to prescribe certain technical requirements for the design of radio equipment. And this is something that we are currently looking at as a way to perhaps prescribe a certain form to industry to embed this principle of privacy by design and by default into certain equipment. For example, we are looking at connected toys in that sense, and we are seeing that perhaps we should take some measures to facilitate that certain requirements would already be integrated in those devices. So there are possibly other ways, but they are not necessarily in the GDPR itself.
Okay, thank you. Isabelle. Guillaume, and then we'll turn it over back to the audience.
Yes, just to answer Ronald's question, because I didn't want it to be forgotten. I think it was very important that we answer. I think you asked how innovation can actually drive. How privacy can drive innovation.
Yeah.
And, I think it's important that we all understand that privacy is all about trust, and it's a good business practice that your consumers trust you. So, as a company, and the GDPR should help a lot on this, we said that it should not be about tick boxes. And if you have a service where you have to ask for a consent on every functionality that you offer to your consumers, then they will start to distrust you because they don't understand why you need this data, because it's not relevant for the service that you are asking them. So it's good business practice to try to ask as little consent as possible, not just because you hide, not because you hide the things that you do, but just because you don't do these things. And so the more you design your products in a way that you don't have to have data, so you don't have to ask for consent, the chances are that you will gain market share because more and more people will trust your services. But this requires, and it worries me a bit, it requires that people understand why privacy is important for them. Like, why should I trust more a service that cares about my privacy? And I'm a little worried on this ground, on the youngest generations who've been born with the internet, with services that collect this data a lot, and they just think it's normal. So I think there's a lot of work to do on an education point of view to just make them understand what the consequences of privacy invasive products can do, and not just that the fact that these companies have a lot of information about you, but what it means in terms of what they can do with this information, how it can be used to manipulate you consciously or unconsciously. So anyway, just to give you an example, like I was thinking of what could be a innovation privacy driven. Let's imagine you have these services online where they offer you the possibility to sort pictures online. Based on, if you would just want the pictures of your children, and you would have a folder automatically done with all the pictures of your child. So you basically just send all your family pictures, sometimes dirty pictures, not with your child, of course, but sorry about this. The pictures, very intimate pictures, the pictures of your trips, whatever, you send them online to a server where you don't control these pictures. Imagine a service where you would have facial recognition based on your own servers. I mean, the algorithms that do facial recognitions are on your computer. The pictures are on your computer. So the folders that decide what are the photos with your children, what are the photos with your wife, what are the photos of your trip in Rome or whatever, it's just done on your own computer. This is a really good advantage that you as a company have over services that require that you upload the pictures to their servers.
So that would mean moving back from the cloud to your local device.
Yeah, and there are companies. There are companies that are really trying to do that today and are having success doing that, and they will have this competitive advantage in the coming years.
We have a caller in a couple of callers in the audience. So can the mic come forward?
Thank you. Nicholas Martin from Fraunhofer Easy in Karlsruhe. So I wanted to return to the question of the host earlier and maybe sharpen it. Two things are widely held to be true. One, consumers are not willing, in general, to pay for privacy. And secondly, consumers expect most online services to be free, at least monetarily free. First question is particular to Guillaume Champeau. Do you believe this to be true? Secondly, if it is true, then how do you monetize services, like search, for instance, that are currently offered for free? Thank you.
Thank you for your question, because it's...
Perhaps except monetizing them except by analyzing vast amounts of personal data.
I mean, there's this sentence that I hear a lot, which is, if it's free, then you are the product. And it's false. Like Wikipedia, for instance, is free. Do you think that you're the product for Wikipedia? No. I won't give names of companies, but there's this huge video distributor, huge video company, streaming video company. You pay for it. You pay monthly for it. But have a look at their privacy policy, and you'll see all the data that they collect and share with third-party companies. So there's no relationship between the business model and privacy. As regard to search engines, we don't need to know who you are to deliver advertisement. So we are an ads-based revenue, but it's just keyword-based. So if you are looking to do a trip in Brussels, you will probably type hotel Brussels in your search engine, and then if we have a hotel who is willing to advertise its rooms in the search engine, because you are asking for a hotel in Brussels, the chances that you click on this ad are quite high. So we get paid by the hotel provider who wants to pay for the ad. So you can develop lots of business models that are just more respecting of that. And even there are companies, and Qwant is one of them, who are working on new technologies that will able to personalize services, perhaps someday even advertising, but with information that will be kept on your site, and we don't need to know, we don't need to collect all the users' information, but each user would give some signal of what they're interested in, so that we can understand what they're specifically asking and offering more suited advertising.
Catherine, you had a question?
Well, just a bit of a comment on your question there first, is that I think Apple iTunes proved that people will pay for something that they can get for free online as well, as long as it's showing the value and the quality there. But yeah, I work, sorry, my name is Catherine O'Keefe. I work with Castlebridge, which is a company in Ireland that one of the things we do is we consult with some startups. And regarding the question of innovation, one thing we do work with companies that are trying to do very good privacy by design ideas. One of the problems they're having is finding investors who understand that. So I think that question there, yes, privacy can drive innovation, but how do we get the investors and the funders to understand the quality there?
That's a good point.
I don't want to monopolize, so I'll try to be short. Hopefully, Qwant will help, because I joined Qwant a year ago. I was the 50th employee. Today we are 150, so we are traveling, have triple size in just 1 year, and the trend is going this way. So we are a living demonstration that doing privacy by design can be a successful business model, and we should be at break-even this year. So financially, it's doing well. So if you have companies in Europe that are able to show that it's an actual business model that works, then we are inspiring startup creators who will try and go into that direction, because they know they have understood that it's the way to compete with the American and Asian services that don't have this kind of background.
Okay, we have another question here.
Hi, my name is Federico Benedetto, and I work for a company in London which is called Privitar, and some of you may know it. We build privacy enhancing tools that companies may use to try to implement some aspect of data protection by design. So I have a comment and a question. So the comment is on the innovation aspect. I think it's also some of these companies that come to us, they have internal practices or internal governance structures that limit the amount of things they can do with their data. If a data scientist has an idea of analyzing some internal data sets to improve the processes of the companies, they may ask access to the data, and after 6 months, someone will tell them, no, you can't have it because it's too risky. So some of the reasons why they come to us is that they might want to use privacy by default to allow for these processes. The question is, on a different note, what's the state of the art? Because Article 25 mentions that. Is that what comes out of university, or is that what's widely adopted in the industry? Thank you.
Well, I think let's ask the Commission what they thought about state of the art when they drafted the text.
It's a general reference to the state of the art, because as you all well know, technology is just evolving every day, and so we wanted to have a regulation that can stand time, and therefore we cannot be too prescriptive. I mean, I think it was mentioned at the beginning of the panel that you have to leave room for implementation. Each processing has its specificities, and I think this is the flexibility is there in this article to tailor those products and processing operations to the specifics of it. So I think it's a general reference. It will evolve. There are standards today for doing a number of things, and they will continue to evolve. The state of the art is referring to that, to the standards we have today, but those we may also have tomorrow that are currently being developed.
Yeah, and it might look to standards, for example. But Nina wanted to take the opportunity to quickly touch on the IoT and kids connected toys.
Yes, because I find this tremendously interesting that the European Commission wants to take up privacy by design and privacy by default rules for connected toys. Because I think, especially in this area where you don't really have a display where the user can interact with, it's really difficult to apply privacy and data protection by default rules. And what I'm concerned about with data protection by default is if companies have a very broad purpose that is only decided by their business model, might they actually take choices away from the customer only to not be forced to have defaults? This is what I'm really concerned about. So will we have fewer choices only to have fewer defaults? This might happen, and we have to think about how to communicate with the users, and for defaults we also have to take into account what is the realistic expectation of the user when he is dealing with that toy. So might the expectation actually to have an offline product and be surprised by the connectivity? So I'm really interested to see what's coming out of these regulation ideas.
May I add something to that from discussions that we had a while ago on these smart toys? One of the things, and that is actually something that you might be able to regulate, is that toys are typically handed down from one child to the next. And if you have a sort of an intelligent connected doll or whatever, so that doll is being trained on the one child, and what happens if you pass that toy on to the other? Is there a sort of a right to be forgotten to be implemented here, that if you press a button on the doll, that he or she forgets about the first child, but retains part of the things that it has learned and be placed on the next context? So that is something that you can concretely think about how to handle such a scenario, which is not entirely made up.
And then to take Nina's point also, yes, we mustn't forget that it may not have a user interface. It may be a voice-activated device or a toy. So when it comes to a child's internet-connected toy that's voice-activated, how are you going to determine that I'm the guardian, the legal guardian, you're the parent, because the law says that actually you can't process data when the child's of this age? And these are the other kind of things. And then, yes, the association and disassociation of identities, for example.
Well, there are two things. One thing is the mention I made of the radio directive on radio equipment is the possibility is a tool. That's all I wanted to say. Is a tool for us to impose requirements on also on manufacturers of products in order for them to design those products in a privacy-friendly way. I was taking this example because it's quite in the press, and also there are lots of investigations on connected toys by data protection authorities. And therefore, this triggers the reflection. Are there a possibility to impose certain requirements for the design of these products so that this would limit the risk and the harm to children? That's
yeah, that is what we were expecting already. So we need to wrap up in a couple of minutes. Pat, do we give the speakers an opportunity to say famous last words for this panel individually?
The famous last words?
30 seconds.
Coming from maybe really like from my personal view on this thing, if you have a...
Can you speak in the microphone?
Sorry, yeah. So I would say, because I'm a direct Finn, if you have a crap business model, basically you shouldn't be having that business model. I mean, there comes a time when the legislator is the one who says what is okay and what is not okay and how to protect the fundamental rights. Even if the people themselves don't want to protect their rights, I mean, it is our obligation to do so. And therefore, I mean, what I would say is that there is maybe one kind of a role for the legislator as well to push for that sort of innovation that actually respects the laws and respects the principles that we have in our democratic societies.
Just to go in the same direction, I would say that if you have a damaging business model related to human rights, not only you shouldn't do that, but you shouldn't be allowed to do that, and you shouldn't be let to do that. So I'm hoping the public authorities and the public as a whole can really protect users from accessing products that are damaging for their privacy. And if it's damaging for their privacy, it's probably damaging for a whole lot of other human rights. So it's really something that we should keep in mind as a society.
Yes, I agree with the previous speakers. I would just, well, I'm curious to see also how this, how the enforcement will be on these aspects by the data protection authorities. I also hope, as I mentioned before, that there will be able to give a bit more guidance on that. And I also, I'm curious also to see about the certification mechanisms that may develop, that are being currently thought through, and whether they would also provide sufficient tools for that.
So I can repeat that I'm actually happy with Article 25, and I think it has all the opportunities to foster innovation in this area, to not hinder innovation but foster innovation in the area of privacy enhancing technologies. And I want to second Isabelle in our hope for more guidance from the DPAs on what is actually considered to be state of the art, what are the thresholds we will have to meet, and in addition to the enforcement, more guidance and more consultation.
Yeah, from my perspective, if I can have 2 seconds, it's to take that point that yes, there's definitely a need for guidance. When I talk to clients and others, and even from Simon's point earlier, not only is the need for guidance and clarity from a regulatory perspective, but I think also to collect information from an industry perspective, what are the good examples and how are some of the innovators actively doing with this?
Yeah, in my closing remarks then, I think we need carrots and sticks. The sticks are provided in the GDPR. We have to comply with this, with Article 25 and others, but there's also carrots. We need to have showcases of good examples of decent services that respect human values and the things that we care about. And hopefully we will have panels next year where we have these showcases, but also the horror stories of people who are fined, punished, and what have you. For now, I'd like to thank the panelists for their contributions. So let's give them a hand of applause. And also to our audience for being here, and to be continued. Thank you.
Thank you.